We have found ourselves in an unprecedented time. For the first time in American history, a former president has been indicted for at least one crime. That distinction now goes to former President Donald Trump, tied to a hush money payment made to allegedly cover up an affair. In addition to this, he stands accused of lots of other crimes. That's what we're talking about today. I'm Stephanie Haney, and this is Legally Speaking. Right now, there are 4 separate criminal investigations underway looking into actions taken by former President Trump. In New York, he's been indicted on at least one charge tied to the hush money paid to an adult film star. Other prosecutors are looking into classified documents that were being kept at Trump's Mar-a-Lago estate, potential election law violations in Georgia, and interference with the overall 2020 election and the resulting riot in Washington, D.C. on January 6, 2020. As we break down what charges the former president could face, we'll check in with these 3 former federal prosecutors on what they think is most likely to happen in each of these cases.
My name is David DeVillers, and I'm a partner at Barnes & Thornburg. I was the former U.S. Attorney for the Southern District of Ohio.
I'm Subodh Chandra. I am a former federal prosecutor and a former City of Cleveland law director and prosecuting attorney. I currently am the managing partner of the Chandra Law Firm, LLC. We do civil rights work along with some white-collar criminal defense work.
Kevin McMoneagle. I am a tenured professor at Case Western Reserve University in Cleveland, and I teach criminal law and some other related subjects, evidence, legal ethics. Before I went into teaching, I was a federal prosecutor in the Northern District of California.
Let's start in New York. Here's where this case stands. Now we've learned a grand jury has voted to indict Trump on at least one charge over hush money, an agreement made with an adult film star, Stormy Daniels. This is made just days before the 2016 presidential election. Now, we won't know the exact crime or crimes he's accused of committing until Trump has his first court appearance in this case. That's called his arraignment. But here's what we do know, summed up very nicely by U.S. law enforcement editor for the Associated Press, Mike Balsamo.
Donald Trump has said he never had sex with Stormy Daniels and never had an affair with any woman. But what we know from testimony before House and Senate panels, as well as testimony given in federal cases, is that Donald Trump did know about the payment that was made to Stormy Daniels. His personal attorney, Michael Cohen, has admitted that he was directed by Donald Trump to make that $130,000 payment to keep Stormy Daniels quiet, despite the fact that Trump said he had no knowledge of it.
In this case, the potential New York State charge is bookkeeping fraud, the falsification of business records. That's all about the way this payment was recorded. Now, this has a possible sentence of up to 4 years in prison if it was done with the intent to commit, help along, or conceal another crime. And remember, this case started as a Department of Justice investigation where Trump's former attorney and fixer, Michael Cohen, the person who paid the money to Stormy Daniels and then got reimbursed by the Trump Organization, pleaded guilty to criminal tax evasion and campaign finance violations. Here's what former federal prosecutor Subodh Chandra had to say about that.
There's already been a conviction of Michael Cohen, the former president's former lawyer and fixer. And so when you have a situation as a prosecutor where you've prosecuted the accomplice, the person who was out there doing the bad deed for the principal, it really is not good optics to not prosecute the principal who benefited from the fixer's conduct. There's no question under these circumstances I would charge. You have a situation in which hush money is paid. Weirdly enough, it's reimbursed by the Trump Organization when there's no conceivable business benefit to the Trump Organization for Donald Trump personally having hush money paid to silence someone in the middle of a campaign. So there are a number of parts to this. There's a number of elements to the criminal offense that you need to have good evidence for. But I don't see how you can not charge when Cohen has already pleaded guilty to the offense, and there's no one other than Donald Trump who would benefit from the payment of hush money. It's not a situation where the former president can say, well, gee, I didn't know, or I didn't benefit. Well, who else is going to benefit? So I think this is a situation in which there needs to be a prosecution to complete the investigation and prosecution that was already undertaken. Because if you don't do that, what you have is a situation of unequal justice in which the person at the top of the pyramid somehow benefits from escaping prosecution, whereas the underlings get prosecuted. And that's not something that prosecutors like. That's not something that the justice system should like.
Given the possible connection here to a federal crime, there is the question of whether a state or federal prosecutor should be handling this case. Former federal prosecutor David DeVillers believes it should be a federal investigation.
Now you're talking about, all right, who should be handling cases like this? Should it be the Attorney General or the U.S. Attorney who answers to the entire country? Or should it be a local prosecutor, the Manhattan prosecutor in this case, that really only answers to a tiny portion of the country? And that's a legal, moral, and political question that I think we're going to be dealing with here in the next few weeks.
Do you have an opinion on that?
I really do think that if there's a federal crime and a state crime that match up against a former president, in this case it would, then it should be brought by the federal government, not a local prosecutor, because that's just going to set bad precedent down the road.
Now, the former president reacted to the indictment, saying this is a political persecution and election interference at the highest level in history. Now, there's no evidence that this prosecution has anything to do with Trump's plans to run again for the presidency in 2024. Despite that, he's calling this a political move and calling this prosecution by Manhattan District Attorney Alvin Bragg a favor to President Joe Biden. President Biden hasn't reacted publicly to news of Trump's indictment at this time. Now, in terms of the timing of these cases, if former federal prosecutor Kevin McMonigle were taking these cases, he'd prefer that it be in a different order.
If I was doing it, if I had the choice of all four of these cases, I wouldn't lead with the hush money one. That's, in some ways, that seems like the best one to lead with because it's the easiest. But I actually think that since it doesn't have the sort of traditional feel of a crime, unlike the Fulton County one where they're committing perjury. So I think I wouldn't do it any differently than what they've done. I just think it wouldn't be the ideal one to lead with.
Okay, now let's move on to those other three open criminal investigations. Let's talk now about the classified documents found at former President Trump's Mar-a-Lago home. It was in December of 2021 that a Trump representative told the National Archives that presidential records had been found at the home, nearly a year after Trump left office. In January 2022, 15 boxes of records containing some classified materials were found and taken from Trump's Florida home. A few months later, federal officials served Trump with a subpoena for more documents believed to be at the estate. That August, FBI agents executed a search warrant in Mar-a-Lago and retrieved 33 more boxes of documents. This was after lawyers for Trump gave a sworn statement that all government records had been returned. So let's take a look at where this case stands now. This is especially interesting. A federal appeals court directed one of Trump's attorneys to turn over documents in the investigation. Now, you might be thinking now, what about attorney-client privilege? How can this happen? Well, it can happen in the most extreme circumstances, like when someone uses the services of their attorney to commit a crime. This is not the kind of ruling a judge takes lightly. Former federal prosecutor Mr. Chandra explains.
It's not many federal prosecutors who find themselves in a situation where they're going after the testimony of a target of investigation's lawyer. That just does not happen very often in our system. And there's a reason for that. And that is that we have a justice system which attorney-client privilege is pretty sacrosanct, even though it's a derogation of the search for truth, and you potentially cut out a knowledgeable witness from an investigation. We so value in our rule of law as Americans the ability for people to be able to get legal advice and to be able to have those unfettered conversations with their lawyers to get guidance, because that's part of our structural system on the rule of law. We want people to go get that advice. And so as a consequence, as a general rule, we have this attorney-client privilege that is relatively inviolate, but only relatively. There are limits to attorney-client privilege. And one of those exceptions is the crime fraud exception. Now, what does the crime fraud exception mean? It means when an investigation is happening and the prosecutor determines that it appears that the advice was sought or used in furtherance of a crime or fraud by the person seeking it, then under those circumstances, you can go to the court, you can go to a judge and say, listen, there should be no regard for the attorney-client privilege here because this activity of talking to the lawyer was used in furtherance of a crime or fraud. An important thing to note is the lawyer doesn't have to be in on it. The lawyer doesn't have to be a co-conspirator. The lawyer doesn't even have to know that the advice and the relationship is being misused in furtherance of a crime or fraud. What matters is that the principal, the client, is using that information in furtherance of a crime or fraud. Now, what you have to understand is how not only is this unusual for federal prosecutors to find themselves in this situation, but the number of internal checks and controls at the Justice Department before you can even ask a judge that are significant. You have to go to your supervisor. You have to go to your supervisor's supervisor. When I was in the U.S. Attorney's office, we had to go all the way to the U.S. Attorney, 3 levels up. Then from there, you have to go to the Justice Department, and there's an office that determines whether it's reasonable to request this from a judge. So what we have here is a situation in which there have been multiple checks on whether or not this investigation could reach the information from Evan Corcoran. And the fact that now 2 federal judges, one in Los Angeles, one on the East Coast in Washington, have determined that Donald Trump apparently used legal advice in furtherance of a crime or fraud, that's an incredibly significant fact. And it means that the underlying evidence on which they are relying has to be explosive and convincing to federal judges who are neutral.
Now, in this case, Trump could be facing any of 5 different charges. Under the Espionage Act, unauthorized retention of national security documents, and those don't even have to be classified documents. Now, that carries a prison sentence of up to 10 years per document. Second, concealing records to obstruct the official effort to get presidential records back to the National Archives. That's punishable by up to 20 years in prison per offense. Third, mishandling official documents. This would be tied to the former president ripping up presidential records. That penalty is 3 years in prison per offense. Fourth, contempt of court, tied to a May 2022 grand jury subpoena that Trump received requiring him to turn over all classified documents. Now that could result in a fine of up to $1,000 and up to 6 months in prison. And fifth, conspiracy to make a false statement. This would come into play if the former president and his attorney agreed to lie about having more classified documents at Mar-a-Lago. A conviction on this charge could mean 5 years in prison. Here's what our panel of former federal prosecutors think about the likelihood of an indictment in this case.
I've had a classified status as well. And, if I had those documents, I'd certainly get in trouble. Whether you'd get indicted ultimately or not, that's usually up to a prosecutor's discretion. And in this case, Merrick Garland's discretion. Just because there's a grand jury investigation or a search warrant doesn't mean it will ultimately result in prosecutions. But if you looked at the letter of the law, then if you could prove that it was intentional, either retaining or taking the documents, then yeah, that's a federal crime. I think we should enforce our laws equally amongst everyone. And if we're not doing that against one person, we shouldn't be doing it. If we're not doing it against everybody, then we shouldn't be doing it against anybody.
They have the FBI agents going in doing the search, so they don't need a lot of cooperating witnesses. They had the FBI agents find the documents in his office and various places in Mar-a-Lago. So that would be a very, very easy case to prove by just calling the agents.
Now let's take a closer look at the criminal investigation in Georgia dealing with election law. Here's where things stand now. Ironically, as the former president refers to his indictment tied to a hush money payment to stop a story about his alleged affair as election interference, the Fulton County District Attorney is investigating events related to Trump's attempts to overturn President Biden's narrow victory in the state in the 2020 election. Among other things, in a phone call that was recorded and leaked, Trump called Georgia's Secretary of State and pressured him to find more votes to flip the outcome.
I just want to find 11,780 votes.
We know that in this case, Trump could be potentially charged with election code violations, which are usually misdemeanors in Georgia, but there are several felony charges being considered. One of those is a racketeering charge. In Georgia, this racketeering charge can be used against members of any group that engaged in a pattern of criminal activities with a common purpose. Now, a conviction on this charge could mean up to 20 years in prison. Let's check in again with Mr. McMonigal, Mr. Chandra, and Mr. DeVillers to get their thoughts on what we'll see here.
That's probably the biggest one going on. That's probably the most consequential in a lot of different ways. But yeah, if there was pressure from the government, from the president himself, to try to convince either the state or the state officials to circumvent the law, then yeah, that's going to be a crime, and both federal and state. It can be a federal and state crime. So I think, yeah, that's probably the bigger question. And again, all these questions depend on what's going on in front of this grand jury, and we're not going to know those answers for months, if ever. If there's no indictment, if there's a no bill, then we may never know the answers to what happened, what testimony and what documents and evidence was recovered.
It does appear that in the Georgia election fraud case that we have a prosecutor who also seems to be determined to move forward to charges. Now, I can't be sure of that. It could be that the prosecutor is taking all the steps to properly investigate, and at some point will back off and say the prosecutor doesn't have the evidence of intent. But it does appear, again, based on what's been publicly reported, that this is a bona fide, legitimate investigation. And it doesn't just arise, I think there's a common misconception. It just arises from what Donald Trump refers to as his perfect phone call to the Secretary of State telling him to find more votes. That's an incredibly troubling call. But it does appear that there were so many other actions that were taken, including trying to orchestrate a fake slate of electors, and a number of other efforts to try to delegitimize the election result, that when you put all of those things together, I think that it is, I'm not a betting person, but if I were to place a bet, I'd say that it's more than 50% likely that we'll see criminal charges out of that investigation, just based on the evidence that's been publicly revealed. I would want to know a little bit more information than what we've seen publicly revealed, right? While I do not believe at all that Donald Trump was so self-deluded as to believe that he somehow won the election. He's just not that stupid. He's cunning, but he's not stupid. And so I don't believe that he would have the defense of, oh, he sincerely believed that he had won, and so he was trying to get a more legitimate result. I don't subscribe to that at all. There was just too much information, too much data, and we've already seen public reporting about his friends and associates who were all telling him that he lost. So he knew he lost. So that piece is in place. But I would want a little bit more information about what specifically he did. And one of the things that the people watching need to keep in mind is that one of the most important tools, two of the most important tools that prosecutors have, are the charge of conspiracy and the charge of attempt. Okay, or aiding and abetting is another one. And so the conspiracy charge allows prosecutors to charge even when someone isn't successful in their efforts to engage in illegal activity. The same is true of attempt. The same is true of aiding and abetting. And those broad tools are tools that it does seem that, given the number of people that Donald Trump was in contact with, including some lawyers engaged in shady activity, that he may very well be facing a charge. I think charges would be appropriate, but I would want to see a little bit more information to convince me of that.
They have Trump on tape making a statement, false, encouraging the governor to change or the Secretary of State to find him some votes. So that, and then the other thing is that there's a lot of other people involved. Rudy Giuliani, there's a whole bunch of people that could be thrown into that as well. And that increases the possibility that they might make deals with some of those others to have them testify against President Trump.
Parts of the investigation in Georgia were a part of the broader federal investigation into the events of January 6th. The House committee that carried out that investigation into the riot last year recommended criminal charges for Trump. The bipartisan committee voted unanimously on these charges: conspiracy to defraud the United States with an up to 5-year sentence, obstruction of an official proceeding of Congress punishable by 20 years, conspiracy to make a false statement, again carrying a possible sentence of up to 5 years in prison, and aiding an insurrection, punishable by up to 10 years in prison. Now, that was also a first in U.S. history, the first time a congressional committee has approved criminal referrals against a former president. But keep in mind, those referrals are just recommendations. They don't carry weight on their own. Special counsel for the Department of Justice is still investigating this issue and the 4 potential charges referred by the House January 6th committee. Former Vice President Mike Pence has been subpoenaed to testify before the grand jury in the investigation tied to January 6th. And most recently, he said his legal team is looking into what he must do now if he will be required to comply with that subpoena. All 3 of the former federal prosecutors I spoke with were the most skeptical about whether this DOJ investigation would end up going anywhere.
So from what I've seen and read, so that is it incitement and insurrection, and I don't believe it gets there. I don't believe it gets to the level of incitement from what we've seen so far. There was an insurrection, as you know. We assisted with the January 6th insurrection here in the Southern District and Northern District of Ohio by in support when it took place, and we took it very seriously. But the idea of, all right, is this get to the level of incitement? And I don't think it's a matter of law. From what we know so far about President Trump, from what we know from the hearings, I don't believe it does.
So I think this is one of the more challenging charges for a prosecutor, because on the one hand, Donald Trump has his First Amendment right to free speech and to say all kinds of outrageous things. He has that, as do the rest of us. On the other hand, he was in a position of power and authority and seems to have been engaged in a series of acts that were intended to obstruct an official proceeding, namely Congress's certification of the official result based on bona fide votes and based on court rulings from judges appointed by both Democrats and Republicans who said that these were legitimate votes and this was a certifiable election result. So from a prosecutor standpoint, you have to prove what Donald Trump knew and when he knew it. And then you also have to prove what did he actually do. And I think it's got to be more than just simply outrageous speech. It's got to be some sort of conspiracy. It's got to be incitement. It's got to be some sort of effort to aid and abet the insurrection that was taking place. I do think from the public reporting I've seen, including from the New York Times, that the elements of it are all there. So I think if we had a detached prosecutor looking at all of that evidence, including what the January 6th committee in Congress elicited from witnesses, and including from witnesses who we've probably not seen, but the prosecutor has seen in front of the grand jury, I suspect that the elements are there and that Donald Trump will be charged. Again, if you ask me to place that bet, and I'm not a betting person, I'd say there's a greater than 50% chance. One of the things that gives me confidence if he is charged is, first of all, we have a special prosecutor in charge of the investigation, someone who's not tied to any political party or administration, who's right down the middle and has been a career prosecutor. And I think the second thing we have going for us, again, is that we have all this presentation being made to a grand jury that ultimately is going to make the charging decision. Now, while the presentations to grand juries are one-sided, I suspect that the prosecutor, to be fair, is also putting evidence that Trump himself might want in front of the grand jury, and they're going to make a decision. So of all of the different matters we've discussed today, it seems to me that the January 6th matter is the most important and vital to our democracy. The classified document, the national defense document issue, is serious to our national security. But the January 6th investigation is most vital to our having a functioning democracy. And no one is supposed to be above the law, including former presidents. And if we have a former president who aided and abetted and conspired to overturn a valid election result, and indeed also conspired to commit insurrection and to encourage and aid and abet insurrection and sedition, that is probably the most serious matter that I've ever heard of, including, I'm old enough to remember Richard Nixon's crimes. I mean, you're talking about something so monumental that if we fail to hold him to account for that conduct, no matter how unpopular it might be with some segment of the public, then we have failed in our commitment to the rule of law.
I think that one is harder to prove. Just as an example, I showed in my criminal law class this past year, had the students watch his speech, the entire speech, and told them about the tweet he did about Pence, which was I had them watch all of them, and then I gave them little index cards, and I say, all right, you're the jury. Do you think he's guilty or not guilty of aiding and abetting the January 6th assault? And it was about 2/3 of the students convicted him. And about 1/3 said, well, we don't think he's innocent, but we think there's a need for more evidence. And of course, there would be other evidence. But so I just wonder how easy it is. When I look at that speech, I think, oh yeah, you could convict him in 2 seconds. But of course, I'm a former prosecutor, and I tend to think that way. So that one, I think, is going to be a little harder to prove in terms of exactly what it was he was in on. Although some of the there's some testimony saying, a couple of the ladies that worked on it said him sending that tweet about Pence was like pouring gasoline on a fire. And you can't imagine a better metaphor for inciting a crime than pouring gas on a fire. So I just wonder about my conversation with my students about, did they think those things were enough, and that they seemed a little more hesitant, some of them. And I thought they would all come back and convict him. But so anyway, I think that one's a little harder to prove, and that might take longer. That's the one I think they might hang back with a little bit more. And it may be that if they nail him on the Mar-a-Lago and the Fulton County ones, these other ones, they might not have to prove so if they get a felony conviction on any of these, especially on the Mar-a-Lago one, they're probably not going to need to do the January 6th ones.
Now, here's something to keep in mind. In each of these cases, an indictment doesn't necessarily mean a criminal trial will happen. After an indictment, lots of things can happen. There could be a plea deal, for example. There's no trial needed if there's a guilty plea. Now, that is highly unlikely in any of these cases, but also charges could be dropped. It happens all the time when the prosecutor doesn't think that they can reach that threshold of proving a crime was committed beyond a reasonable doubt. Even so, legally speaking, we have now seen something in the U.S. that has never been seen before. Former President Donald Trump is the first person who has both been president and has been indicted in a criminal investigation. We'll keep you updated as these cases move forward. Thanks for being with us. I'm Stephanie Haney.